Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And I already told you, we have to make another update on what happened with the Ripple v SEC lawsuit earlier today. So that is exactly what we're going to be talking about in this video, specifically about the new letter which Ripple and the individual defendants just filed. All right, on behalf of defendants Barrett Garlinghouse, Chris Larson, and Ripple, we anticipate filing a letter request for a local Rule 37.2 conference to address a discovery dispute between defendants and the SEC, collectively the parties, regarding the latter's assertion of deliberative process privilege with respect to documents withheld in this litigation. The parties have conferred and believe that a modest page limit extension would facilitate the presentation of these issues for the court's consideration. We therefore respectfully request that the court grant the parties leave, 1. For each of defendants and the SEC to file 8-page letters, and 2. For the SEC to have 5 days to respond to the defendant's letter. We are available to respond to any questions. And as far as I know now, from reading into this, in the easiest words, what this means is Ripple and the individual defendants, they're not happy with the way that this deliberative process privilege has been used by the SEC. And so they want to basically get a conversation going where Ripple and the two defendants put up a letter of at maximum 8 pages, or I should say differently, exactly 8 pages. And then it will allow the SEC 5 days to respond to it with an additional 8 pages. If I'm not mistaken though, I believe then Ripple actually has the chance to reply with another 8 pages because that's the way that these things go. Ripple puts up their first initial idea, SEC puts up their response, and then the Ripple can put up their reply to the response to kind of slam down their points. At least that's what I think. So, with that said, what is it going to be about? Why are we so excited about it? And why did I want to make a separate video about it? Well, I want to, first of all, open up a discussion and let you guys also think with me here about what exactly it is we are missing. I've expressed throughout the last couple of days, I think that this lawsuit makes absolutely no freaking sense. And I want you guys' opinion on that one right now too. Do you guys agree with me that this Ripple v SEC lawsuit makes absolutely no sense? And I mean that on quite a lot of different points. A couple of the points said earlier, why hasn't Ripple gone deeper into this privilege stuff like a couple of weeks ago? Why not before the William Hillman deposition? Why not object? Then the question is, what exactly could they question William Hillman on? Then it is, why were all Ripple members deposed and others are going to be deposed, yet we never heard about any of that stuff? We never heard about any of the critical factors regarding what Ripple could be hiding. Why? Right? Why did we never hear anything more about the SEC hiding all these documents? I mean, we're hearing about it now, yes, but it's been so many weeks. Why wait so long? What's the holdup? I have no clue what they're waiting on. Why has there been no decision on John Deeden's motion to intervene? Why has there been no decision on so many other small parts? Why have we heard nothing now from the earlier motion to strike Ripple's lack of fair notice defense? I mean, that one was basically backed up because of the SEC's own party saying that there hasn't really been clarity. Yet, Ripple stopped and didn't provide their last letter, which they could have done a couple of weeks ago. Like, why? It is all so extremely vague, and I don't get the way that these things are going. And as quite a lot of lawyers have said, in all this legal stuff, it is war, and so they have proper strategies to win the war, not every small battle, but the bigger picture. I get that, yet it's so difficult for us as outstanders to understand the process here. I mean, had the crypto bill, for example, the infrastructure bill, had any influence whatsoever on this lawsuit? Yes or no? I don't know. Have all these other smaller lawsuits that I've been looking at, and guys, make sure you understand, I look a lot at different SEC lawsuits. Have they had any effect? Are they waiting for something else? What is Ripple waiting for? What are they doing? And that's just a side, right? That's my initial point that I wanted to bring up. I just don't get that. Yet this deliberative process privilege is extremely important for a multitude of reasons. I have a couple of things open right here. Let's kind of open up a discussion. So I have about 3 things open. I think they're all in order as well. So this one came out first, July 9th. The SEC says Ripple is not entitled to testimony on the XRP on XRP from the ex-director. Is William Hinman, a former high-ranking SEC official, exempt from disclosing his prior communications on XRP, or must he provide testimony to Ripple? The basis of this question actually has to do with exactly that: deliberative process privilege. Defendants want Director Hinman to sit through hours of questioning, where an SEC lawyer repeatedly objects and instructs him not to answer, just so defendants can use the deposition transcript to argue to this court that the SEC is not entitled to assert a deliberative process privilege. Stewart wrote in response to an earlier court finding by Ripple, quote, "This strategy is not an exceptional circumstance justifying the deposition of a high-ranking SEC official, as virtually every agency enforcement action involves pre-enforcement, prejudicial, privileged deliberations." The SEC asked the court to quash the subpoena issued to William Hinman until after a decision is made on the SEC's motion to strike Ripple's lack of fair notice defense. That the SEC did not provide Ripple with fair notice that XBitrue's violated the law, as that motion, if granted, could render Hinman's deposition irrelevant. Yet, as I just explained to you, that is actually the initial point, and actually the entire point behind this all. Hinman clearly was a high-ranking SEC official, Stewart argued, and the SEC actually put up, adding that Hinman's supervision of registration and disclosure requirements was critical to the SEC's operations and to that of the United States capital markets. Calling Ripple's argument that Hinman was not a high-ranking official ironic, Stewart wrote, as defendants cannot point to a single case where a deposition of an SEC official of Director Hinman's rank was allowed, which is actually pretty dumb, as the judge also explained, yet the judge did think he was a high-ranking official, so that one she did give. Yet here's where things get interesting. Defendants are thus asking this court to make new law, which is not true, by ordering the deposition of someone who held one of the highest-ranking positions, which is also debatable, within an independent federal agency, I guess that's true, in order to question him about external meetings, about which they could depose other participants. And that's also not completely true, because in the end of things, the SEC is making it seem as if whatever William Hinman said, there was always somebody else there. Not true, right? William Hinman is the only person who could know what his stance on XRP was at the time, what exactly he discussed with other parties. And you might say, you could just ask other parties. Well, in this specific case here, William Hinman is the only one who can think about the intent of why he did something. So he is the only person which could be asked for this. And about internal SEC deliberations that are privileged. Stewart wrote, adding that it was contrary to legal precedent and it posed significant burdens on the witness to the parties in the court. Well, yeah, let's get back to that one. What exactly are we talking about here with what is privileged, right? SEC deliberations that are privileged? Well, referring to Ripple's claim that Hinman has unique first-hand knowledge about the SEC's communications with third parties and about the agency's adoption or approval of his well-publicized speech in 2018 about the regulatory treatment of crypto, Stewart argued that Ripple was simply wrong in claiming that they are entitled to elicit Hinman's testimony. As once more, if defendants wish to discover facts asserting the SEC's assertion of deliberative process privilege, and later to litigate it, they can ask the SEC, the party asserting the privilege. The SEC has already produced and will continue to produce privilege logs covering internal communications relating to the speech, Stewart wrote. And one thing they actually did quite lately, not too long ago, is they actually gave Ripple a privilege log. And as far as I know now, the privilege log basically shows a list of all the documents and which documents they think is privileged. Now, the strange part is that Ripple has gotten this entire document quite a significant while ago, and we all thought that Ripple would make a fuss about the earlier Bitcoin, Ether, and XRP documents, and that this would all be useful in asking William Hinman questions, and that they would bring it up to the court, yet they never did. So, right now it leaves us wondering, what exactly did the SEC put down as privileged in their log? Did Ripple get their official log to the fullest extent, or only a part of it? And have they met and conferred about it, or what? Because mind you guys, it is only what we see that we can note on. Ripple and the SEC actually meet up, let's say 2 to 3 times a week to discuss things. That's all stuff we don't really see. Now, the SEC had already produced and will continue to do privilege logs covering internal communications relating to the speeches, Stewart wrote. Defendants will not be able to obtain better, more detailed information from Director Hinman than they would already have from the SEC's privilege log. Communications with third parties have already been provided by the SEC to Ripple, Stewart added, pointing out that Ripple could seek information from third parties directly without the SEC's permission or court intervention. Yet, Ripple basically wants this speech and everything around the speech. And the SEC is saying no, and that's also what the dates kind of show here as time went on. They're basically keeping arguing that the speech itself is completely privileged and most things around it are also privileged. Right? And Judge Nepern asked why the SEC said that privilege would be breached if the scheduled deposition is about a public speech based on his personal views and not on behalf of the SEC, as the agency argued. Hinman's 2018 Ethereum speech was the central question for the judge. The SEC admitted that the staff participated in the drafting of the speech. Ripple's counsel added that the ex-SEC chair, Jay Clayton, told Congress that the speech was an example of transparency on how the agency was treating crypto. And then again, guys, let's do 2 steps back here. So the SEC says, no, we can't give it out because it's a speech from an official SEC member. It's an official opinion from our, party. So since he wasn't, an official at the time, we cannot give that out. Yet the judge asked, well, why not? If you're saying it's his own opinion that he put out there, and it's nothing official, we can't hold any rules towards it. It's not done on behalf of the SEC, right? So it's not actually an agency opinion. It's just a personal opinion that he did for fun. It's like, for example, Donald Trump going to talk somewhere off duty just because he likes that. It can be used against him in court, right? It can. If he's saying something as the president of, which is not, again, let's call Biden as an example. If Biden goes somewhere as president of the United States and talks about something as president of the United States, everything he says, that's completely within his position to do so. If he goes to a freaking pub, right, he talks about what he likes to do to his women. That has nothing to do with him being the president. I mean, he does that because he likes it out of himself, if you know what I mean. So that can be used against him in court. Yeah, it's just he's still a person. Not all of a sudden everything somebody does because he's a hired government official is exempt. And here specifically, at least that's my opinion, right? If he says, and that's again the big conclusion that Ripple wants to draw here. If he says that everything said in there was his own personal opinion, then Ripple can see all of that stuff, can use all that stuff, which is juicy. On the contrary, if it was only his opinion, then he did not give clarity to the markets. Yet, if the SEC drafted the letter, if they looked through it, and the main focus of this speech was to give clarity, well, then things get kind of shifty again as well. Because if the main purpose wasn't clarity, then why did he give the speech? Right? And who did he talk with before and after? Ripple wants to get all that information because it's going to help them to understand exactly what the market was kind of aware of at the time, what their thoughts were, if the SEC is corrupt. All that stuff can be uncovered just from one small little speech. And the deliberative process privilege is actually a key part of that because it's basically going to outline exactly where Ripple stands in getting information from the SEC and what parts of it should they hold dearly, basically. The SEC argued that anything Hinman ever said is privileged as deliberative and told the judge the deliberative process privilege would be invoked if Hinman was deposed. Despite the ruling going in favor of Ripple, the blockchain firm's counsel complained that the SEC is withholding every part of the internal memorandum, citing privilege and its position, is untenable and prejudicing the defense. Ahead of the hearing, John Dean, the attorney who had previously filed a motion to intervene in the same FXP holders and name, published an opinion piece with his line of questioning for the deposition. Well, all interesting, yet our question at the end of things basically is this right here. What did Ripple ask the SEC? Why was this issue of deliberative process waited on for so long? And what's about to happen now? Because let's read the last part. This was first, this is why I did it in this kind of manner. This was July 9th. This was July, let's see here, 15th, and this is July 21st, if I'm not mistaken, or 20th. Despite the understanding reached between SEC and Ripple, some remain skeptical about the progress made. Quote, I will be surprised if the parties do not come to her after deposition to get a ruling on the privileged deliberative process issue, said XP Holders attorney John Deaton, which again, they have now done. They may have agreed to ask certain questions and allow him to answer those questions under seal and then get a ruling after the fact. Because guys, this is my own personal prediction. Ripple asked William Hinman all the questions that they wanted. And actually, William Hinman gave an answer to the majority of them. Yet they can only use them if they actually win this specific document. If they win this motion, basically, which is about to be filed, then they can use the answers that William Hinman gave if he did not, not answer them, basically. But they've basically been filed under seal, which basically means that Ripple knows and the SEC knows, but nobody else can see them. or use them until, once more, it is basically determined that it is up for discussion and it's going to be brought up in court, basically, that they can be used, right? So I guess that's actually really strange because, like, for example, if some information is privileged, right, and you file it for under seal, but for example, somebody says, "Oh yeah, I've murdered somebody," you already know, right? Ripple, for example, Ripple's side knows the stuff that William Jimenez said, yet they cannot use it. That must be really frustrating. If he said some key evidence, but it's quote unquote privileged, that would be freaking annoying, man. I couldn't really cope with that. But guys, hopefully you got my little conclusion right here. There's so many thoughts that I had, and that's why I wanted to dedicate an entire video to it. But hopefully I didn't go astray too much from my original opinion, which is just, it's such a strange little situation. Yet hopefully all of that stuff is going to be found out right now as we speak. I really, really hope so. In terms of price, I'm still extremely bullish on it, guys. Even though in terms of Bitcoin, I'm actually kind of not, that positive about the price. Ethereum was looking quite good with its retest, and XP was also looking quite good with its retest. So from that perspective, okay. But Bitcoin once more, if it were to go down right now, I wouldn't be too sad about it, as I know that things are really looking a lot more bullish than earlier. And also, guys, as you most likely know, I'm still extremely bullish on XRP and a lot of different crypto out there, so I have a long position open. I might just open some more long positions pretty shortly here just for the fun of it, because once more, I think it's about to make us a whole lot of freaking money. Right now, there's $1,600 worth of bonuses over on BITRUE, so this trade right here has done for completely free. Just got myself $500 without it costing me anything, because once more, on BITRUE, you can get $1,600 worth of bonuses for free. And sometimes, every here and there, there's other bonuses that you can grab. Pretty shortly here in a couple of days, there's going to be a really big competition where millions of XRP are going to be given away as well. So make sure you check it out. A link is down below. And I'll see you guys again in another crypto video.